Alcolu, South Carolina, was a place most people never heard of. In 1944, it was a small mill town tucked between pine trees and train tracks. A place of dirt roads, Sunday church bells, and factory whistles. A quiet town. But also a divided one. Alcolu was split straight down the middle, white families on one side of the railroad, black families on the other. Two separate worlds, side by side. White children went to white schools. Black children went to black ones. They didn't play together. They didn't sit at the same lunch counters. That was just how it was. In this world, George Stinney Jr. lived with his parents, his brothers, and his sisters in a small house provided by the lumber mill where his father worked. George was 14. He liked riding his bike. He liked helping his mother around the house. He was thin, quiet, and smart. People who knew him said he was polite, soft-spoken, just a kid trying to grow up in a place that didn't give boys like him many chances. Then came the day that changed everything. It was March 23, 1944. Two young white girls, Betty June Binnicker, age 11, and Mary Emma Thames, age 7, went out looking for wildflowers. Along the way, they passed George and his little sister Amy. The girls asked if they knew where to find maypops, a kind of flower that grew near the railroad tracks. That was the last time anyone saw Betty and Mary Emma alive. Later that evening, when the girls didn't come home, their families went searching. The whole town turned out to look. Flashlights cut through the woods. People shouted their names. But there was nothing. The next morning, their bodies were found in a shallow ditch near a railroad. Their heads had been crushed. It was brutal. No one could understand how something so violent could happen in their quiet town. Within hours, suspicion turned toward George. Not because there was clear evidence. Not because he was seen at the scene. But because someone said they'd seen him talking to the girls the day before. That was enough. He and his older brother were arrested. The brother was released. George was not. He was taken away from his family without warning. His parents weren't allowed to see him. He was questioned alone, no lawyer, no adult, no protection. He was 14, thin, weighed 95 pounds. Just a child. But in the eyes of the law, and in the world he lived in, George wasn't seen as a child. He was seen as a suspect. A black boy accused of killing two white girls, and that was all it took. He was placed in custody, questioned behind closed doors, and kept away from everyone who might have protected him. No parent. No lawyer. No witness to what was being said or done inside that room. He was 14 years old. A child, left alone with white officers in the Jim Crow South. What happened during that interrogation, how long it lasted, what was said, what was promised or threatened was never properly recorded. There was no audio, no transcript, no signed statement. Just the word of the sheriff, who later claimed George confessed to the killings. That single claim that George confessed is what the entire case rested on. No physical evidence tied George to the scene. No fingerprints, no bloody clothes. No weapon found in his possession. The girls' bodies were discovered in a shallow ditch. Their heads crushed by a heavy metal object, possibly a railroad spike, but no one could say for sure. Despite that, the sheriff said George told them everything. He said George admitted he wanted to have sex with one of the girls, followed them, and killed them with a large metal spike when they resisted. There was no one else in the room when this confession supposedly happened. No lawyer to challenge the details. No recording to review. Just one story written down by the man in charge and passed along as fact. George never had a chance to explain his side of the story in that moment. And once the word confessed was used, there was no turning back. He was taken to the county jail in Columbia, over 50 miles away from Alcolu, for his own safety. There was fear of lynching. Rumors spread quickly through the white community. Angry voices called for swift justice. A mob gathered at one point. There were whispers about storming the jail. The sheriff moved him to avoid bloodshed, but that didn't stop what came next. Back in Alcolu, George's family was forced to flee. His father lost his job at the mill. Their home company owned was no longer theirs. They left in silence, afraid. Afraid that what had already happened to George could happen to them too. Meanwhile, the state moved quickly. Just 30 days after George's arrest, a grand jury, all white, all male, indicted him for murder. There were no defense motions. No independent investigation. Just the machinery of the court, moving swiftly, confidently, and quietly toward one outcome. George's trial was scheduled for April, just 1 month after the murders. He was assigned a court-appointed attorney, Charles Plowden. He had political connections but little trial experience. He made no formal objections. He filed no motions to suppress the supposed confession. He did not challenge the fact that George had been questioned without a lawyer or parent. He called no witnesses for the defense, not even George's sister, Amy, who had been with him when the girls came by that day. Her testimony, which could have placed him far from the scene of the murders at the right time, was never heard in court. The trial lasted just 1 day. The courtroom was packed. Reporters were there. People from both sides of town, white and black, came to watch, but only white citizens sat in the jury box. 12 white men. They heard the prosecution's version of the story. They saw photographs of the victims. They heard the sheriff say George had confessed. That was enough. Charles Plowden offered no closing argument. He didn't question the confession. He didn't push back against the rushed investigation. His client was 14, but he did nothing to ask the court for mercy. He said nothing of George's age, his size, his inability to fully understand what was happening to him. The jury deliberated for just 10 minutes. That's all it took. 10 minutes to decide that George Stinney Jr. should die. The judge sentenced him to death by electrocution. No appeal was filed. No petition for clemency was submitted. The court system moved on. George was taken back to jail, and the state prepared for the execution. He was now the youngest person in modern American history to be sentenced to death. There was no pause, no second thoughts. In the eyes of the law, justice had been done. 2 white children were dead, and the black boy accused of killing them had been convicted, quickly, cleanly. But for those who paid closer attention, something about the whole process didn't sit right. A child had been accused, tried, and sentenced to death within the span of just 83 days. Without a defense. Without proper evidence. Without time to breathe. This wasn't just a legal proceeding. It was a rush to judgment. And for George, it was a door that closed, one he would never have the power to reopen. After the verdict, George Stinney Jr. was moved from the county jail to Columbia, South Carolina's Central Correctional Institution, a tall, grim facility with thick concrete walls and narrow barred windows. He had just turned 14. He was the youngest person ever sent to death row in 20th century America. There, he waited alone. No family nearby. No one allowed to visit freely. His mother once tried to see him, but was told she couldn't touch him, only look at him from a distance. She cried. He cried. But that was the rule. Inside his cell, there wasn't much. A thin mattress, a worn blanket, a sink, a toilet, and time, a lot of time. Time to sit with the weight of a future that had already been decided. George had never been in a courthouse before this trial. He had never seen the inside of a prison. He didn't know what was happening to him, not really. The adults around him made the decisions. The guards told him what to do, where to stand, when to eat, but what no one gave him was comfort or fairness or time to understand. In those final weeks, he asked for his Bible. He prayed. He talked to the chaplain when he could. But most of the time he was alone. No stay came. No lawyer returned. No newspapers took an interest. Just the same silence that had followed him since the day he was arrested. A silence that said, "This is how it ends." Then came June 16th, 1944. That morning, George was given his last meal. Fried chicken, mashed potatoes, and milk. He didn't finish it. A few hours later, guards came for him. They brought him from his cell, led him down a narrow hallway. He walked slowly, quietly. No resistance. No words. In the death chamber, the electric chair stood waiting. It was built for adults. Big, heavy, made of oak. George was too small to fit. They had to stack books on the seat to raise him high enough. His arms barely reached the armrests. His feet didn't touch the ground. The guards placed the straps across his chest, his arms, his legs. They placed the leather mask over his face. But it was too large. During the execution, it slipped. Witnesses said his face was briefly visible as the electricity surged through his body. The current ran once, then again, and again. And just like that, at 7:30 a.m., George Stinney Jr. was pronounced dead. His body was removed from the chair and taken away quietly. There were no flowers, no music, no proper grave at first. Just a 14-year-old boy, killed by a system that never really gave him a chance to live. Outside, the town of Alcolu went on with its day. People went to work. The train ran on time. The mill opened. And George's name was already being forgotten. His family buried him in an unmarked grave behind the church they once attended, the same church that refused to speak his name again for decades. His mother and father never recovered. His siblings moved away. They carried his memory like a wound they couldn't explain to anyone. For years, nothing changed. There was no review, no hearing, no apology. George was gone. And the world seemed content to leave him that way. After George Stinney Jr. was executed on that quiet summer morning in 1944, the world moved on. There were no headlines that lingered, no community uproar. The courtroom emptied. The reporters left. And his story, in many ways, was buried alongside him in a grave without a name, behind the very church his family once attended. His parents never recovered. They moved away in silence, carrying the loss with them. His siblings, too young then to understand all of it, grew up with the shadow of George's death pressed deep into their lives. They didn't talk about it. In many homes, the memory of George became something too painful to revisit, and too dangerous to keep alive out loud. In the years that followed, Alcolu changed slowly. The mill closed. The town faded. But George's story stayed buried, forgotten by many, remembered only in the hearts of the few who had loved him and never believed the accusations. For decades, the state of South Carolina stood by the verdict. It remained on the books. George Stinney, 14 years old, executed for the murder of 2 white girls. No questions, no appeals, no apology. But memory has a way of surviving in quiet places. In the early 2000s, George's family, now older and scattered, began to speak out. They wanted to clear his name, not just for him, but for the generations that came after. To reclaim what was taken. To put truth on record, even if justice had come too late to save his life. In 2013, nearly 70 years after his death, a new petition was filed to vacate his conviction. It was led by a group of lawyers, activists, and members of George's family. They gathered documents, dug through court records, and looked again at everything the original trial had left out. The missing alibi, the lack of evidence, the absence of due process. Witnesses who had never been called in 1944 finally had the chance to speak. Amy, George's sister, now a grown woman in her 80s, returned to tell the court what she remembered. She said again what she had always known, that George had been with her the day the girls disappeared, that he couldn't have committed the crime, that her brother was innocent. Other voices joined hers, scholars, historians, legal experts, all agreeing that the original trial had been a farce, a legal process in name only. And for once, the court listened. On December 17, 2014, Circuit Judge Carmen Mullen issued her ruling. She vacated George's conviction, calling it a fundamental constitutional violation of due process. She wrote that the case had been rushed, that the defense had been completely inadequate, and that the so-called confession was likely coerced. 70 years too late, but finally, George Stinney Jr. was declared innocent. It didn't bring him back. It didn't undo what had been done. But it gave his family something they had never been allowed before. Truth, spoken out loud, with the weight of the law behind it. And yet, the story doesn't end there. Because George's case isn't just about one boy, it's about a system. A system that, in 1944, didn't stop to ask if justice was truly being served, because the face of the accused didn't matter. His age didn't matter. His innocence didn't matter. It was about race, about fear. About a world that decided the life of a black child was small enough to fit into an electric chair built for men. The music shifts, slightly heavier now, with more space between each note. In many ways, George Stinney's story is a mirror. It reflects what happens when a legal system moves faster than truth, when fear is louder than fairness, and when a child's life becomes a footnote in the machinery of punishment. It raises the question, how many other stories like his have gone unheard? How many trials were decided before they ever began? How many names were never cleared? George's name is no longer among them. But his story remains, not only as a tragedy, but as a warning, that justice delayed is not always justice done. That silence can stretch across decades. But sometimes, just sometimes, truth catches up. And when it does, it speaks not with thunder, but with quiet, human clarity. We failed him, and we must not fail again. And to end it, let me share with you some facts. Today, George's grave remains at Calvary Baptist Church, now marked. South Carolina's last use of the electric chair was in 2008. Children as young as 13 were executed in the U.S. before the Supreme Court banned the practice in 2005, Roper v. Simmons. Over 170 people have been exonerated from death row in the U.S. since 1973. How just is the justice system? If you found this story fascinating, chilling, or downright unbelievable, hit that subscribe button and turn on the notification bell so that you won't miss any of our subsequent stories.